I want to talk about the main obstacle to settling a personal injury case when you're involved in a motor vehicle accident. In other words, the other party's at fault. So the insurance company, for openers, is going to want to believe that the other party's at fault. And it's easy to say, well, he was at fault. But the question always is, how do you prove fault? And even though there's more, I want to talk about three main ways to prove fault. One is through testimony of yourself or a passenger in your vehicle. In other words, you have observed what happened. You saw the guy run the stop sign, you saw the person make the wrong illegal turn or do something else. So your testimony about how it happened is one leg of fault. Number two is what the negligent party said to you. So if he or she gets out of the car and says, hey man, I'm really sorry that I ran that red light. Hey man, I didn't see you. Or usually they use dude today. Hey dude, I didn't see you. Then you have testimony, you have what's called an admission from his mouth. And that is another part of proof to prove that he was at fault. If he gets up and says, hey man, you ran the red light, you've got some real trouble. The third way is the physical evidence. In other words, you can tell a lot of times from how the crash occurred and where the person hit, who's at fault. And not all the time, but that's a good way to do it. And that happens in rear-end accidents. It happens in front-end accidents where the damage is just to a side of the bumper and not the whole bumper if they're turning. So the insurance company is going to dissect the facts, and it's important for you to marshal all the facts if you want to win on the question of liability. But let me tell you this: the other side can be at fault. You've got all the facts marshaled, and the insurance company will look you straight in the eye and say to you, you're at fault. They do it all the time. Don't buy it. Don't go away. Don't take it. Get yourself a lawyer.